All right, I think we're going to go ahead and get started. So, welcome. I am Jeff Hirsch. I'm a faculty member at the University of North Carolina School of Law. I first want to thank Bill Herbert and everybody else here at Hunter for putting on a great conference so far and inviting me. We're obviously here to talk about collegiate athletes, particularly their classification as employees or something else under our labor laws, although as we'll see as well, this is an issue that of course touches on a lot of other things, a lot of other legal doctrines, other issues that employees and frankly other members of society at large oftentimes have to face. So it's kind of hard to pigeonhole or limit this issue into one little small box. So we'll see that today with the great panelists that we've got. They're all going to speak for about 15 or 20 minutes, give or take. We might have a little discussion amongst ourselves for a bit. After that, we'll have to see where that goes, and then of course open it up to everybody else for Q&A. I think this issue in particular is a good one for a lot of interaction with you all, so we'll look forward to that. I'm going to give a super brief introduction to folks because nobody wants to hear me talk any more than they absolutely have to. So first we'll hear to my left, Josh Nadro. I totally asked you how to do that and then messed it up. Off to an awesome start as usual. He's at Fisher & Phillips, and he's going to be talking to us primarily sort of giving us the managerial conference view, if you will, of this issue. Following him will be Gabe Feldman, who's on my right. He is, among many other things, the director of Tulane's sports law program, and then the associate provost for NCAA compliance. I will forgive him for being a triple Duke graduate. Sorry, local joke. And he's going to be largely giving an overview of some of the unique labor issues involved with this, as well as I think there's some antitrust and other stuff that'll slip in there as well. And then finally, we have Mark Gaston Pierce, who of course many people know as the recent former chief of the National Labor Relations Board, and is now currently, again, among many other titles, the executive director of the Workers' Rights Institute at Georgetown Law. He also will be talking about some similarities, but then looking in particular at the impact on racial disparities that's oftentimes involved with collegiate athletes. So with that, I'm going to go ahead and turn it over to Josh.
Thank you, Jeff. Good afternoon, everyone. I want to thank Hunter College for having me here, particularly on a panel like this. Any panel with labor and sports that has Gabe Feldman and Mark Pierce, and for some reason me, it's really a point of privilege to be here. I kind of learned labor law reading and sports law reading what Gabe and Mark have done, and so to be on a panel with them, sort of surreal. I think what we'll start with today is the Northwestern University decision from 2015. But before I jump into that, Jeff made a comment, looking at employees, looking at independent contractors, or something else. I think one of the themes that comes through as we talk about, our student athletes, employees, our, gig company workers, employees, all these things that are sort of permeating the labor and employment sphere they all come from the same problem. We're trying to fit, 21st century concepts into 18th and 19th century doctrine. And so you'll hear throughout my comments sort of who should decide these issues, and really it's for the policymakers. I'm not going to surprise anyone that the management lawyers up here are saying, it's not for the agencies to decide, it's for Congress, knowing full well that Congress can't do anything. So as we go through there, just keep that in mind that, a lot of the tension in these doctrines is because we just are putting, square pegs in round holes sometimes. So back to Northwestern, the efforts to change college athletics for the better, at least from the student perspective, have certainly existed for decades with limited success. But from the labor perspective, the first real effort was in 2014 when a group of grant-in-aid football players, and grant-in-aid for those of us who aren't labor sports nerds, that's synonymous with scholarship. So a group of scholarship football players at Northwestern filed a petition with the NLRB to form a labor union. And to answer, the question presented was, are these people employees? And if they are, is it, under board law, should they form a labor union? And to answer that question, the regional director used common law factors that had been decided, if you will, by the Supreme Court in a case called NLRB versus Town and Country. And that established a three-part test. Do the proposed employees perform services? Are those the proposed employees, do they receive compensation for those services? And does the putative employer exercise sufficient control over the putative employees? In a well-detailed opinion, the regional director concluded yes on all three. With respect to the services, the regional director stated that between 2003 and 2012, the Northwestern football team had generated more than $235 million, which in the regional director's mind at least were the result of the services rendered by the football players. Likewise, and probably not to many people's surprise, the regional director concluded that scholarships, which often exceeded $76,000 a year at that time, were compensation in direct exchange for the services provided. And then the regional director spent a significant amount of time detailing the day-to-day life of a Division I FBS football player, particularly at Northwestern, concluding that the control was pervasive, that the rules imposed by Northwestern were clearly controlling over the athletes, and that the athletes typically devoted 50 to 60 hours a week on football-related activities during the season. The case then went to the full NLRB for review of that decision, which included, among other people, my esteemed colleague Mark, and now board chair McFerrin. In a unanimous decision from the Democratic majority board, declined to assert jurisdiction. And in doing so, they made it painfully obvious that they were not deciding whether football players were employees under Section 2.3 of the National Labor Relations Act. And they noted 4 different times that they were assuming, without deciding, that issue. And they reached this conclusion. Well, and they ultimately found, even if they are employees, that that it didn't, that they would not assert jurisdiction over the petition and declined to allow an election to proceed. And they reached this conclusion based on 2 key issues. One was the interrelation between Northwestern's football team, its conference, the Big Ten, and the NCAA. The board likewise did not believe it was wise to assert jurisdiction where only a fraction of football bowl subdivision teams played for institutions subject to the act. And I'll get into that a little bit more, but the National Labor Relations Board does not have jurisdiction over public actors, I think, and you probably know that already, but that was a key part of the ruling. Finally, the board found that single team bargaining units raised practical concerns. So while Northwestern, as a private enterprise, was subject to the NLRA, it was the only private school in the Big Ten. And they looked at this and said, when we deal with union petitions and issues in professional sports, we've never dealt with it on a single team level. And the way that teams interact with their leagues or their conferences, that matters. And there's a great quote, by their very nature, team sports are carried out jointly by the teams in the league or association involved. And there is no product without direct interaction among the players and cooperation among the various teams. They recognize that this is different than most private enterprise, and because they could not assert jurisdiction over the vast majority of the teams, they declined, noting that it would not promote stability in labor relations. And like I just noted, a big part of this was the makeup of Division I football bowl subdivision. At the time of the decision, 17 of the 125 institutions competing in that level of football were private and therefore outside the board's jurisdiction. Likewise, a number of the 17 private institutions are or were religious institutions, which may or may not be subject to the reach of the act, sort of depending on the standard that's in place and depending on which board issued the last decision. But the remaining 108 public schools undeniably were not covered by the act. As the board noted, it could not assert jurisdiction over public entities, and in fact, at least 2 states with public institutions in Northwestern's conference expressly excluded scholarship athletes from collective bargaining under state law. And as we all know, a number of other states either ban collective bargaining entirely by public employees or have not expanded such rights to employees or students at their higher education institutions. So for the time being, Northwestern ruled that there would not be a players association, at least in NCAA Division I football, bowl, subdivision football, a mouthful. A lot happened between 2015 and 2021, which I know my co-panelists will cover to some extent. You had significant developments in antitrust law as applied to the NCAA. You had significant developments in wage and hour law as applied to the NCAA. But fast forward to 2021, President Biden is elected in 2020, sworn in. Before he got off the podium at the Capitol, he fired the NLRB general counsel. Eventually, the current general counsel, Jennifer Abruzzo, was sworn in. She issues General Counsel Memorandum 2108, declaring that it was her prosecutorial position that certain players at academic institutions are employees under the Act. And she used that phrase, players at academic institutions, as an acknowledgement to the fact that the term student athlete had historically been conceived as a way to prevent these athletes from attaining certain rights or benefits typically connected to employment. I think historically that term came about in the context of a wave of workers' compensation claims against NCAA institutions. General Counsel's memo announced 4 points of emphasis, some that apply to these athletes and some that just describe labor law more generally. First, she reasserted the position that under her discretion, she believes that college athletes are employees under the Act, declared that merely calling these players student athletes is an independent labor law violation akin to misclassifying someone as an independent contractor versus an employee. Third, she announced a much more expansive stance on when and whether political activity is protected concerted activity under the National Labor Relations Act. And fourth, she suggested, in direct response, I think, to the board's Northwestern decision, that she would use a theory of joint employment to effectively bring all of the NCAA's revenue-generating sports under the auspices of the Act, despite, again, the fact that the overwhelming majority of institutions are public. And I'll talk a little bit more about that because I think that's going to be one of the most significant issues coming out of her memorandum. But before we get there, I do want to touch on some of the sort of more discrete labor law issues. The first one is that one dealing with misclassification. Her theory that merely identifying someone as a student athlete in this case, or more broadly, an independent contractor, is a discrete violation of labor law, is currently directly contradicted by existing NLRB law. A case called Velox and another case called IBT. Both were issued by the Trump administration's NLRB, finding that merely calling someone, putting a label on them, is not a separate violation. And then for those of you who don't have the misfortune of practicing labor law, at least not in the private sector, it's not uncommon for the NLRB General Counsel to announce a list of cases where the law may or may not be consistent with their own positions and publicly acknowledging that they're going to advocate to change that law. But that's what she's doing here. She believes that those cases issued during the Trump administration are not an accurate or helpful reading of the NLRA. And so she's seeking to change that. And I know Mark's going to mention, a non-sports case where she's making that same pitch. And I do think that there's some tension there. Section 8C of the NLRA essentially protects an employer's right to legal opinions. And by announcing that someone is an independent contractor, or in this case, a student athlete, the employer is essentially stating their opinion. So there may even be some constitutional implications about, is the NLRA being used to infringe an employer's free speech? But one wrinkle, I think, in the context of student athletes is that in the statutory definition of employee under the NLRA, independent contractors are specifically excluded. So if an employee were to read Section 2.3 of the Act, knowing that their employer has at least told them that they're an independent contractor, they could conceivably lead to the conclusion that, I'm not an employee under the Act, so therefore I don't have any protections. The term student athlete is not specifically excluded under the NLRA. So a student or a collegiate athlete who is interested in labor law, who reads the NLRA, would not necessarily reach the same conclusion about her or his status under the law by knowing that their institution calls them a student athlete. So I think while this is sort of an issue, again, that is permeating throughout labor and employment law generally, I'm not sure it necessarily, that the student athlete case is the best vehicle for the general counsel to argue that merely labeling a student athlete that instead of an employee is a labor law violation. I mentioned that the memo also addresses what the general counsel believes or what level of conduct, particularly political conduct, should be protected by the Act. Under a number of long-standing decisions, the board, courts of appeal reviewing the board, have held that there has to be some nexus between the political activity and the employee's terms and conditions of employment. So, in theory, advocating to increase the minimum wage, if an employer or an employee were disciplined for that type of conduct, there's that substantial nexus, right? We're talking about wages. There have been cases that talk about, advocating for employment safety standards, those types of things. Those are things that are connected to employment. What the general counsel speaks about in her memorandum here, and in particular talks about, athletes who have engaged in recent examples of activism concerning racial justice issues, such as the support of the Black Lives Matter movement. Those types of issues, at least under existing NLRB case law, do not directly concern the terms and conditions of employment absent some tie to the workplace. So for political speech, which most, at least in the management bar, would consider Black Lives Matter to be, you need to be that. You have to have that tie directly related to work conditions. This issue is actually being litigated in a case involving Home Depot right now. Subsequent to when the general counsel issued her memorandum on this topic, an administrative law judge concluded that at least under existing law, merely writing Black Lives Matter on a work apron does not necessarily convert the issue into a workplace issue. And that administrative law judge dismissed the complaint, finding that the alleged protected concerted activity was not substantially connected to the workplace. That case is now on appeal with the full NLRB, so we may see a change in this, but this, as applied to athletes, there was a significant amount of activism in 2020. A large amount of it arose during COVID. You had players, social justice movements. I think that the hashtag was "Let Us Play." We had, for one of the first times, star players at various institutions kind of coming out in support of their colleagues, their friends, their teammates, and willing to kind of put themselves on the line. And this included, my favorite Alabama quarterback, Mac Jones, now plays for the New England Patriots. It included other people who were, high-level draft picks, which is somewhat unusual because these athletes, as some of my colleagues I'm sure we'll talk about, do have so much to lose by sort of putting their neck out on the line. And finally, the memorandum concluded with sort of my favorite issue of this bunch, and the one I've probably spent the most time researching, is that public institutions will be nonetheless subject to the general counsel's prosecution under a joint employer theory of liability. And to establish her, at least, legal support for the idea that the NLRA, which expressly and explicitly carves out state actors, can somehow nonetheless be sort of tortured into covering them, she cites to a case known as Big East Conference, which dealt with whether or not the Big East Conference referees were employees under the Act. And in that case, there was no question that the referees were employed by the Big East Conference. The main question was whether or not the board could assert jurisdiction because the Big East Conference had some public school members as part of its makeup at the time. At that time, there were 2 public members and then 7 private school members. And there, the board was comfortable asserting jurisdiction because public school members were incapable of controlling the conference's operations. There were only 2 out of 9 members. And it wasn't about students at the member schools. It was about the conference's basketball referees, which I think, is a distinction that is worth noting here. And as I think I touched on earlier, there's not a single conference in NCAA Division I FBS football that has a majority of private school members. There are 130 FBS teams. There are only 18 of which are private. And so even if Big East were applicable to suggest that the board can take jurisdiction over employees under a joint employer theory, which really wasn't even what was being articulated in Big East, you're going to have a problem because under the board's decision, the makeup of those conferences was the determining factor. And you're not going to have a single conference that has a majority of private members. So this will be the biggest, the most litigated question under these cases. There's pending a charge right now against the University of Southern California, which, as everyone, well, maybe not, but the University of Southern California is a private institution, despite maybe its name suggesting otherwise. There was a sort of concurrently filed charge against the University of California, Los Angeles, which is a public institution. That case was dismissed on the grounds that it is a public institution and it's not subjected to the National Labor Relations Act. But the case against Southern California is currently in a prolonged investigative phase. But the general counsel in the region in Los Angeles has announced that absent settlement, which is probably unlikely, it intends to issue a complaint there. So that will probably be the first forum where whether or not the NCAA or USC's conference, the Pacific 12, can be subject to the board's regulations on a joint employer theory. And I think that whatever happens in that proceeding, the case will end up before the full board. And I think it'll be interesting to see how the now chair, McFerrin, reconciles her position in Northwestern with a ruling that the athletes are employees under the act. But I suspect Mark may have some commentary on that issue too. And like I started at the outset of my remarks, I think the biggest question is whether this should be the NLRB deciding this issue in the first place at all. College sports were prevalent in 1935 when Congress passed the NLRA, and there's no indication that Congress ever envisioned application of the act to such athletes. How and whether to apply federal labor law to FBS football or other sports isn't really something the NLRB was created to opine on, and I think the best solution to this and other related issues would be best left for congressional action, though as I said at the outset, I can also acknowledge the likely futility of that approach in the current Congress. So with that, I will turn it over to Gabe.
All right, thank you. And it's great to be here. It's great to be back in my home state. It's great to be next to a rival and highlight, I think, part of what makes this conversation so complicated and different is that college sports, like professional sports, have long argued, and I think in many cases successfully and probably rightly argued, that they are different than other industries. And if you take my alma mater, Duke, against UNC, if they were traditional competitors, we would treat them very differently than we treat them as part of the NCAA. Traditional competitors try to drive the other one out of business to gain more market share. And that competition is what leads to benefits to consumers. It's why we have antitrust law. It's why the rest of the world has competition law, because of the benefits of competition. But there's a recognition that sports are different because what makes college basketball and what makes the NFL, when Duke plays UNC, Duke wants to beat UNC on the court, but Duke doesn't want UNC to go out of business. Well, and then Yankees and Red Sox, Jets and Patriots. Again, we may We do want, as Jets fans, the Patriots to stop cheating, but we don't want them to go out of business. Right? Was it the? Well, I'm talking about deflating footballs too. Not
That
just
didn't
Spygate.
even happen.
Not just Spygate. Sorry, I lost my train of thought. So they to have an NFL football game, you need to have the teams cooperate. To have a Sony flat screen television, you don't need Sony to cooperate with LG. And there's a recognition by the courts in lots of different areas of law that sports are different because of that interdependence of their competitors. Although they compete off of the field, they compete for fans, they compete for players, they compete for sponsorship dollars, they compete for coaches, they compete for lots of different things, but they also need to cooperate for the product to exist. And that has led to different treatment under a number of different areas of law. Right? This recognition that sports are special. The question is, though, how far does that special treatment extend? How far should it extend? Because Josh closed his comments with something to the extent of the NLRA was not intended to apply to college sports. It was not intended to apply to a lot of things that weren't really the way they are today back in the 1930s. And almost every industry would like to say, or has said, we are entitled to special treatment. We're different. We're not why the law was created. But sports have been more successful in making that argument than most other industries. And it's led to some special, different, interesting, unique treatment under the law. And you can think about not only the historical deference to the NCAA under antitrust law, or, and we can ask whether this is special treatment or appropriate treatment, the fact that college athletes are not employees. But you can also think about one of the most infamous Supreme Court opinions of all time is the Curt Flood case, where in the first part of the opinion, Justice Blackmun wrote an ode to baseball. Questions about whether antitrust law should apply to baseball, in saying it should not, and it's a tortured opinion, but no more tortured than the first part where he lists all of his favorite baseball players. And was in the Supreme Court library for weeks on end researching which baseball players to put in the opinion. He was also writing Roe v. Wade at the time, so his counterparts thought he was spending most of his time researching that. They might have been doing both, but in no other industry that I'm aware of will the first part of an opinion be the justice's favorite characters in that industry. And that extends to congressional hearings today about college sports, whether it's Republican or Democrat. During all the hearings about the NCAA, almost without fail, if you notice, the senator or the representative will start by waxing eloquently about their experience watching their alma mater play or them playing themselves. Again, when Google is up there, nobody says, wow, I remember that Google search I did last week, it was so wonderful. People approach sports differently, they think of it differently. Again, lots of other examples. Not only the baseball antitrust exemption, baseball has its own tort rule called the baseball rule, where if a fan is hit by a ball in the stands, you could just apply general principles of tort law, but there's a special carve-out for baseball. Lots of different examples where sports are treated differently. So the question is, or one question is, that I want to sort of frame everything is, are sports special and therefore entitled to special treatment under the law? Or are sports special because they are getting different treatment under the law? Which one is it? Are they unique and therefore deserve to be treated differently, or are they treated differently and therefore are unique? And there's probably a little bit of both in there. But bringing it into collective bargaining and the NLRA, I want to read off some characteristics of athletes that'll sound familiar, and it's kind of the context we're dealing with when we talk about the unfair labor practice charges with USC and just the broader issue of whether college athletes are employees, should have the right to unionize, and should engage in collective bargaining or can engage in collective bargaining. So think about this industry. Billion-dollar industry, generates billions of dollars in revenue. The athletes, the perception is that they're being exploited. They're not getting a fair share of the revenue that is being generated. The athletes are relatively unsophisticated. They are young. Many of them have limited, sometimes no college experience. They are often just happy to be there playing a sport. Many people say I would happily trade places with them, and that they're lucky they get to do that instead of to do real work. That the training that the athletes get is primarily for their benefit, not for the benefit of their institution, or their schools, or their conference, or the NCAA. That most of them will not make it to the big leagues playing their sport. And there is intense lobbying going on at the federal level and the state level to try to carve out a protection so that these athletes will not be deemed employees. All of that, as you probably will be able to guess, is me describing minor league baseball players. And everything that just went on in the last 5-10 years with minor league baseball players. Minor league baseball players fit all those criteria, so does college athletes, right? Everything I said is also similar to college athletes. But minor league baseball players have been fighting on 2 different tracks the right to not be recognized necessarily as broadly as employees as college athletes are. There is a recognition, at least under the NLRA, there's really not been a question whether they're employees, but they have been fighting under FLSA about whether they should be classified as employees. Congress carved out an exemption in 2018 on page 1900 of a 2,200-page omnibus bill that is called Save America's Pastime Act, that carves out minor league baseball players from the FLSA. Because, and I always get parched when I start talking about minor league baseball players, so excuse me for 1 second. What Major League Baseball argued is that if we pay the minor leaguers, it will destroy minor league baseball. Right? Just like college sports is saying if we pay the athletes, it'll destroy it. They also say that minor league baseball players who depending on which one and way you look at it, they get paid during their season, which is about 4 or 5 months, and they get paid about $1,000 a week, give or take. They do not get paid during the off season, even though they are, for example, playing in spring training or an instructional league. Why are they not? Because Major League Baseball argued that they are the ones getting the benefit when they're playing in spring training and in the instructional league. And that if an amateur, a non-minor league baseball player, wanted to get that sort of training, they would have to pay $2,000. So they're the ones who are actually getting the benefit, not the teams. A lot of the same arguments you hear in college sports, that the athletes are lucky to be there. Many would love to trade places with them, that the training they're getting is for their benefit, and that if we pay them, if we treat them as employees, it will destroy college sports. Now, just like minor league baseball is proceeding under 2 tracks FLSA, which has not been successful, and Congress is fighting against them, has fought against them, but on the NLRA front, very recently, the Major League Baseball Players Association were given authority by the minor league baseball players to be their bargaining representative. That was something the Major League Baseball Players Association has not wanted to do for a very long time, for a variety of reasons. And then the minor league baseball players themselves have not wanted to form a union, or chosen not to form a union. Lots of reasons why. The primary one, as Josh alluded to before, was just the fear of the backlash. Right? Very few of them make it to the big leagues. They are relatively uneducated. 30% of them do not speak English. At least 30% of them do not speak English, have no college education. Many of them do not know what a union is, much less have a strong opinion about whether they should join one or not. That finally, for better or worse, we'll find out, but that changed as there was more awareness of the unfairness, some of the perceived exploitation of minor league baseball players. As minor league baseball teams were cut, minor league baseball players lost jobs. As minor league baseball was shut down during COVID, Major League Baseball was not. Minor league baseball players lost their salaries. There was a growing recognition that they needed or could benefit from collective bargaining. And with Major League Baseball Players Association being willing to step in, no subset of players had to step forward and feel that they might be risking their careers. Okay. When we shift over to college sports, we have the same dual track, the FLSA fight and the NLRA fight. The FLSA track is right now in the Third Circuit. The previous two major challenges brought by college athletes to be recognized as employees under FLSA and get minimum wage and overtime pay were rejected at the motion to dismiss stage under the argument, similar to what you hear in the NLRA context, that these are students. They're there primarily for educational purposes, and they are deriving most of the benefit from this. And the economic reality, and there's different terminology used sometimes in the NLRA cases versus the FLSA cases, but the economic reality is this is an educational relationship. This is a school-student relationship, not an employee-employer relationship. They are not there with the expectation of being paid. Now, put aside the fact that they're not there with the expectation of being paid because the schools have all agreed not to pay them, but the general idea is that they're going there to receive an education. They are not like other workers in other parts of the regular economy, the non-sports economy. Well, in the district court in Eastern District of Pennsylvania, Judge Padova, who interestingly is one of the only judges in the country who has narrowly construed the baseball exemption I talked about earlier, has also denied the NCAA's motion to dismiss on the grounds that as a matter of law, college athletes are not employees under the FLSA. And the NCAA filed an interlocutory appeal, which was recently heard in oral argument by the Third Circuit. The three judges on that panel all expressed skepticism of the NCAA's argument. And again, this is just on the motion to dismiss stage, but we're having trouble understanding the argument how college athletes could not be employees based on the services they provide, based on the control that the schools exercise over them, based on how this appears to be athlete students, not student athletes. And if you look at the decisions made by USC and UCLA to move to the Big Ten, the NCAA and the Big Ten and the schools made an argument, well, this is going to be great for their education. The idea that athletes from California, put aside the basketball and the football players, the softball player and the baseball players are going to be traveling from Los Angeles to Indiana for a 3-game series in the middle of the week and then back to California, that decision was made with their education in mind. I mean, it doesn't pass a straight face test. Whether that's a good move or not, let's just call it for what it is. It's an opportunity for these schools to get more revenue from the football deal because the Big Ten has a much bigger football deal than the Pac-12. Call it right or wrong, that's what they're doing. But just don't say they're doing it because it's going to lead to a better education for the athletes. And that's been part of the problem with many of the things the NCAA has done and the conferences have done and the schools have done, is when there is a choice between promoting a student athlete, a college athlete, whatever you want to call them, their education versus generating revenue. 99 times out of 100, the revenue generation wins out over education. And both of you know well the record that was established in the Northwestern case and talked about it at all schools of Northwestern, where we thought, well, if this isn't a school that is prioritizing education over athletics, what is? And there was testimony from some of the folks in Northwestern talking about how they recruit football players and how they recruited Kane Coulter, their quarterback, and the suggestion made was they look at the honor roll for high schools across the country, and then based on the honor roll, they look to see who is really good at football. We know that's not how they recruit. They look for the best quarterback, for the best athlete, and then they look to see if they're academically qualified. But to suggest that it's academics driving it first, and then, oh, let's hope they're a good quarterback, right, is silly. And I think it's counterproductive. And I think it highlights why we're seeing the courts in the FLSA cases, potentially General Counsel Abruzzo, the Supreme Court in the Alston case, which struck down NCAA restrictions on benefits related to education, why we're seeing less and less deference to college sports. Because I'll bring it back to the point I started with. college sports have received special treatment. Part of the reason they've received special treatment is not only that need to cooperate. They've argued in the past they need it for competitive balance. They need it for a level playing field. That argument has been rejected now by most courts. It's also been rejected by the NCAA itself. Former President Mark Emmert admitted, I mean, not that he needed to admit this for it to be true, that University of Michigan is always going to have inherent advantages over Eastern Michigan. They're not on a level playing field. It's different than the NFL, where they are trying to achieve some semblance of competitive balance. Right? They do have a salary cap in place to try to ensure that one team is not outspending the other. But that doesn't exist in college sports. It's a shock that we have two new teams, or three, I guess, first-timers in the Final Four in men's college basketball. But if you can imagine a system, right, everybody close your eyes to think about what it would be like. Imagine a system where all the best high school football players get recruited by and end up going to Alabama and Clemson and Georgia and LSU. Right? That's what they fear will happen if you're allowed to start paying them more. That is the system. The only reason a college athlete, no offense to Alabama State, but choose Alabama State over Alabama is because Alabama doesn't want them. Or Alabama doesn't recognize that they're good enough. Sorry, if you're Alabama State, I knew it. I should have gone with a different state school. Can we delete that part of the recording? Yeah. But there is no real competitive balance in college sports. It's not what they're trying to achieve. But you can argue they're different because they are focused on academics. Okay, we'll grant you that. Pro athletes are not students. And then the long-term argument is that they're also different because they're not being paid to play. Here's what's happened over the last, whatever you want to call it, 1 decade, 2 decades, 3 decades, is that there's been a de-emphasis on education. There's chasing of dollars, chasing of revenue, conference realignment, coaches jumping from school to school, $100 million facilities being built. Coaches are hired not because they are great teachers. Right? If you read some of the amicus briefs in the Northwestern case, the Big Ten, other conferences and schools said our coaches are educators. That's why they're here. They're here to educate. They are educating, but in the last 10 years, there's been $530 million spent at the FBS level on buyouts of coaches who've been fired. Not because they weren't good educators, but because their teams were losing. Schools are spending hundreds of millions of dollars. Billions of dollars are coming in. But it's all around how to put the best football team primarily on the field, not about how to best educate the athletes. Now, maybe at 98% of the schools, I'd like to think Tulane being one of them, there is a greater focus on education. And by the way, Tulane, with their greater focus on education, did beat the vaunted USC football team in the Cotton Bowl. But there's been a de-emphasis on education. There's been a blurring of the line now between whether college athletes are actually being paid to play or come to a school or not through name, image, and likeness. When their athletes getting millions of dollars to come to a particular school so that the school or the third party or the boosters, I should say, get to use their name, image, and likeness in an advertisement or on social media. But they are getting $3, $4, $5 million, where no pro athlete of that level is getting anything close to it. It's transparent that they're getting paid to come to the school. So the less special they are, the less the focus is on education, the more that they seem to be receiving compensation, put aside the scholarship, the grant aid. The greater the question becomes, why are we giving them deference? Why should we treat them differently under the law? Why should they be entitled to a carve-out from the traditional FLSA principles or the traditional Labor Relations Act principles? Why do we need it? The answer has always been because we have to protect this very special thing we have in place. But is it so special anymore? Is it so different? I love college sports. I think many of us in here probably love college sports. But the argument that making the college athletes employees, giving them the right to unionize, entering into collective bargaining, that will destroy sports, that will destroy college sports, It may eventually turn out to be true. They may be right, but it is, I think, at a minimum, a scare tactic. I think it's not fair. And I think it is, and not I think, I know it is the same argument that the NCAA made when there was discussion about providing full cost of attendance to college athletes, an extra $3,000 to $6,000 stipend, that would destroy college athletes, that a bunch of universities would just give up Division I sports because it became too expensive. Major League Baseball argued that it would be destroyed if the reserve clause went away. The NFL argued it would be destroyed if their players had free agency. Last point I want to leave with before I turn it over to Mark. I had my watch here so I could keep track of time, but the problem with digital watches is it just turned off on me, so I don't know what time it is. But what may turn out to be the case is that college athletes are worse off if they unionize. I'm hesitant to say that in front of people who believe, myself, in collective bargaining. But here's the fear. The fear is that just like college athletes historically have been fearful of stepping forward to whether it's to unionize or to act collectively, that fear, it will always be there in an institution like college sports where they have finite careers, where they are young, where they're unsophisticated, where their coaches control so much of their destiny, and where such a small percentage of them go to the next level. There's also maybe the bigger weapon right now, and that scares the NCAA in some ways more, is antitrust law. The fear of treble damages. The Alston case is sort of a drop in the bucket. There's the House litigation that's pending right now that's seeking treble damages for all the name, image, and likeness rights that college athletes didn't have the last 5-6 years. There's going to be a lawsuit to just break open free market compensation completely. Why did Major League Baseball agree very quickly to recognize Major League Baseball players representing minor league baseball players? A big part of it is they're afraid that their antitrust exemption is about to be taken away by Congress or by the courts. They'd rather deal with a union than have to deal with these antitrust suits. If you have a union in place, as most of you know, the restrictions, part of the collective bargaining relationship, are protected under antitrust law, under the non-statutory labor exemption. It may be that the NCAA is better off in a labor posture than in an antitrust posture. And if you think about the NFL players were able to gain free agency primarily through antitrust law. And in 2010, they and the NBA Players Association disclaimed interest in their union, something that even the labor people I talked to that didn't really know what that was. They dissolved their union because they wanted to use antitrust law to get more leverage, to get greater rights that they weren't able to get through collective bargaining. It may be that college athletes are in the same position, that their better route is to go for antitrust law. But my last point is whether it's the NLRA or the FLSA or Congress or state law or something else, it is only a matter of time before college athletes come together to negotiate for and get greater rights.
Gabe, that was amazing. Thank you all for inviting me. Thank you, Bill, who's leaving as I speak. But my fellow jazz lover invited me here, and I regret that I can't stay long enough to go out and hear jazz with him. They shoot horses, don't they? It was a great movie. It was an Academy Award-winning movie about people who were in a dance marathon during the Depression, and one character literally fell over with a heart attack and died in the dance marathon because they wanted to get that prize of, I don't know how much money it was. It was probably like maybe $60,000, something that was huge during the Depression. Well, we look at the college athletes, and as Gabe indicates, there's this fantasy that they lead this charmed life, and why should you pay folks who are doing a child's game. They're playing kids' games. And they're playing kids' games for glory, and they're getting a quote-unquote college education out of it. Well, as has been recognized by all of us here, the NCAA makes billions in profits each year while exploiting unpaid collegiate athletes. Since its creation, the NCAA has barred athletes from receiving compensation, and they can accept scholarships, but there was a big fight as to whether or not those scholarships constituted compensation. The argument was this was an amateur sport, and the gentlemanly ethic of amateur sport would be destroyed. The gentlemanly ethic of amateur sport would be destroyed. And of course, that was subject to some serious questions. The seemingly innocuous term student athlete was coined by the NCAA's president and legal team in the 50s as part of a legal strategy designed to avoid paying workers' compensation, a workers' compensation claim to a widow of a football player who died after an injury he sustained at a game. These concepts are used by the NCAA to promote their own profit and lack legal liability. The NCAA's dynamic is also heavily racialized. Graduation rates are lower amongst student athletes of color than their white counterparts. A recent study shows that just over 55% of black male student athletes graduate within 6 years, compared to 60% of all black undergraduate men, 69.3% of all student athletes, and 76% of all undergraduate students. For decades, the NCAA and collegiate sports have ignored a perception of the industry prevalent in many communities of color, a plantation dynamic, which is predominantly white institutions, NCAA and universities, extracting value from black athletes to pad their own pockets. Racism also drives public opposition to paying college athletes. We talked about the whole notion that these athletes lead a charmed life, and why should we pay them for playing a kid's game? The other bitter reality is, why should we pay these black athletes to play this game when they're only doing what they're doing because of their race? They're athletes, they're physical, that's what they do. Why should we pay them for that? Black people were the single most important predator of white opposition to paying athletes, as a 2015 study found out. It was the negative racial attitudes in these pollings that came out that made a determination or formulated or informed the polling that it was negative about paying college athletes. Now, Northwestern is, of course, something that I probably talked about the most as the chairman of the NLRB, and I appreciate that Josh used every word in the book to describe the situation, but didn't say what everybody else says. And then the NLRB punted. And now it was an interesting time, and it was a case that we had never dealt with before. And it was also during a time that we hadn't decided Columbia University yet, which was the case that specifically dealt with students as employees. It was also a time that we hadn't decided Browning-Ferris yet with respect to the joint employer concept. So the NLRB really wasn't ready to jump out with these pretty significant viewpoints on a college football scenario when there were so many foundational things that had to be decided. Peter Orr was right as rain. He utilizing Town and Country, the case law definitely matched the factual pattern that existed at Northwestern for him to reach the conclusion that he did. We were just not ready, the NLRB. And consequently, amazingly, all the Republicans and Democrats unanimously decided that we would not accept jurisdiction. Now, the board posited that asserting jurisdiction over Northwestern, and as Josh indicated, just one team, would do exactly the opposite of what the NLRB was designed to do, and that is to bring stability to labor management relationships. That decision, if we went with respect to this one team in the Big Ten, would result in instability within that environment. And while, as will be discussed, the GC had alluded to jurisdiction over public schools through joint employer relationship with the NCAA, the board has yet to weigh in on this path. And I am curious, actually dubious, about whether or not they're going to be ready to go there, at least now. Recent legal developments, as Gabe indicated, is NCAA versus Alston. This is where the Supreme Court in 2021 held that NCAA's rules restricting certain education-related benefits like laptops or scholarships for student athletes violate federal antitrust law. Yes, I agree with you, Gabe. You wrap yourself in labor relations, you get that exemption. You don't, you're in antitrust land. The Alston decision leaves the NCAA's core argument for its existence, the concept of amateurism, on shaky ground. Kavanaugh, you know, I like beer, specifically writes, like he's channeling Norma Ray, colleges and student athletes should potentially engage in collective bargaining or seek some other negotiated agreement to provide student athletes a fairest share of the revenues that they generate for their college, akin to how professional football and basketball players have negotiated for a share of the league. Building on this momentum, in October of 21, the NLRB's General Counsel, Jennifer Abruzzo, issued a memo 18-2, stating her prosecutorial position that certain NCAA athletes are employees under the NLRA, something that Josh had mentioned before. But, you know, since I'm old and batting cleanup, I can just repeat myself. All right. So college athletes may well be on the cutting edge of a lot of labor law issues that have been brewing for a while. But the question of students as employees, the questions of what does it mean to have a bargaining unit if the number of students that are in the bargaining unit are constantly changing over the next 5 years. The question of joint employer and independent contractor, all of those questions float around this whole subject matter. and it may, the college athletes may well be the catalyst for a lot of that discussion. Josh mentioned Home Depot with respect to the issues that Jennifer raised with respect to what constitutes concerted activities among these athletes. And he talked about how there has to be a nexus with the workplace. And generally, I agree. But I tell you, I'm teaching a course, and one of the essays that I gave the students was whether or not Home Depot was right. And 100% of my students said the LJ was wrong. Why? Well, Black Lives Matters, a lot of political issues, there is going to have to be an assessment as to whether or not those kind of subjects are subjects that have a relationship to the workplace that may not be directly in the workplace. Now, Home Depot on its facts had nexus that the judge decided to ignore. We're talking about, first of all, a Home Depot that was blocks away from where George Floyd was murdered in Minnesota. Secondly, there was a provocateur at the workplace who was ripping down Black History Month posters and making derogatory statements to Home Depot customers. So all of that was in the zone. There was nexus there. And the question will be what this board will do with that. Will this board use this as a launching pad? Because as many of you might know, the Trump board didn't take much for them to launch off of a case to go into the direction that they wanted to. This case provides a lot of easy facts for those kind of determinations. Initially, and additionally, those of you who are students of labor law remember the Supreme Court's decision in Eastex, which essentially said that workers can advocate for things that are not going on in the workplace if it affects workers as a whole. These workers were handing out leaflets about and the governor signing a right to work legislation and pushing back against certain legislative ventures that they were opposing, advocating for employees that were making less money than the particular individuals who were involved in this case were making. The Supreme Court said that's allowed because there is a greater worker goal that was being pursued. That opens up an interesting argument with respect to issues like football players taking a knee or bringing issues, social, political justice issues onto the field and into the workplace. And that remains to be seen where that's going to go. Now, expanding joint employer coverage is another priority of the General Counsel and may be the vehicle to bring public sector universities into the board's scrutiny. While I'm wondering how far the board is going to be willing to go on that, joint employer coverage ensures that every entity employing a worker can be held responsible for labor and employment law violations. Broad joint employer coverage can help promote compliance with labor and employment laws, and each employer could be liable for labor law violations. It's noteworthy that in the California Court of Appeals in 2019, there was a decision in County of Ventura versus the Public Employment Relations Board, which serves as a reminder that public agencies that have a joint employer relationship may be grounds for potential employment liability when it comes to cases uh, involving the contractor's employees. And who's the contractor here? The NCAA, maybe. And who are the employees? Well, that remains to be decided, right? But it very well could be the athletes. Overturning Velox Express, which is a case that Josh mentioned, is a priority for the General Counsel of the NLRB. Velox Express was one dealing with misclassification. In that case, they found unfair labor practices against an employee, against the employer because of how they were treating an employee that was mouthing off a lot about the fact that they were telling her she was a independent contractor, but then they went about to treating her like she was an employee. And there the Trump board concluded that although the board held that Velox ultimately misclassified its drivers as independent contractors, it found the mere act of communicating this erroneous classification was not a standalone violation of the act. Although the Velox board majority found merit to allegations that the employer disciplined an employee for complaining about being misclassified, it oddly refused to issue an order directing the employer to reclassify the drivers as employees. I would imagine that that would be part of a remedy in a case such as this, even if they did not weigh in on whether or not the employer was committing an independent unfair labor practice by stating that. Member McFerrin, the current chair, dissented, stating that the sole act of misclassifying employees unlawfully implies that they have no rights under the act. So I think that yours is a good question as to whether or not this case, the cases that may come about raise the question of whether or not an employer's quote-unquote free speech is being inhibited by a determination. I think Velox was a bad vehicle because the employer's activities were not exactly pristine. Now the General Counsel is going to be putting that in play and maybe arguing, or definitely arguing, that the act of making that statement is in and of itself coercive. And we can think about a whole lot of things that an employer can say that is in and of itself coercive, irrespective of the employer's motivation. You know those cases where, look, I'm your friend, I'm looking out for you, really, but this union thing is a bad thing, and if you do that, you know, I can't protect you. You know what I mean? Now, you know, that's genuine, heartfelt concern. You know? So I don't know about HC, but you know that is going to be an interesting argument that is going to have to be contended with. Now, misclassification of employees as independent contractors has become so commonplace that NELP, the National Employment Law Project, estimates that at least 10 to 30% of employers misclassify their employees as independent contractors. Misclassification is common in many industries, including home care, janitorial, trucking, and it's the major issue within the app-based gig economy. Misclassification is also an issue of racial justice because it's low-income workers that are disproportionately represented in these industries. So with respect to that, Velox, there's an update. The absent settlement of this complaint that just issued like last week, the NLRB could reverse Velox through a case called Deco Logistics, which is likely to come before the board, but probably more likely to get settled before the board even sees it, based on a complaint issued where the general counsel alleges, among other unfair labor practices, that Deco Logistics violated the National Labor Relations Act by misclassifying drivers as independent contractors. And the complaint also seeks that the Trump board, what the Trump board wouldn't do in Velox, an affirmative order that Deco Logistics reclassify its independent contractors as employees. So that's kind of going to bring that issue to a head. Now, critics like you, Josh, note that the lack of any factual allegations in the complaint demonstrates that the general counsel's attempt to create a standalone violation of the act as a matter of law is what is driving this train. And it'll be very interesting whether or not this board is going to want to take that lead. Religious institutions. Well, we got this case, Bethany, that is still good law that made a determination that the standard that pre-existed with regard to NLRB jurisdiction over religious institutions is null and void, and that many religious institutions are considered to be outside of the board's jurisdiction. Recently, I got a call from a reporter in Jacksonville, Florida, to tell me about this HBCU in Jacksonville, the name of which I can't remember right now, but it is the alma mater of A. Philip Randolph. Okay, thank you. And their faculty, after decades of having a union, was being decertified based on Bethany College. Now, what does that have to do with athletes that might want to unionize? As was mentioned by Gabe and Josh, there's a huge number of colleges that have football teams that may try to exclude themselves on a religious basis. Notre Dame, Baylor, Brigham Young, Georgetown, where I teach, itself is a Jesuit institution. Who knows where that's going to go? So the NLRB's Trump era test is going to be a component in this whole assessment. I'm getting the hook, but I would say this. I want to talk about the name and image rules that was spoken about by both my colleagues here. Bryce Young, Alabama's star quarterback. Yeah, we're talking about Alabama. Is estimated to earn a total of $3.2 million from a handful of large corporations, but others. And why is that? Because of the relaxing of this name and image rule. Is that a bad thing or a good thing? Well, I think it's two-edged. It's causing athletes to consider staying in school longer, which is, of course, a good thing for both the athlete and the school, particularly when we remember the statistics at the outset of my discussion about how much of a low percentage of athletes of color are walking out with a diploma. But the concern also is, are the share in equity that is being meted out to all of the college athletes being issued on the backs of the athletes of color. The football and basketball team, which brings the lion's share of the revenues into the university's community, a lot of that money is going to the tennis team and the crew team. And I don't know if you took a look at a picture of the crew team lately. They're not exactly most diverse yet. And the question becomes, is there still exploitation going on? But I'm going to stop here and maybe we can get into a little bit of conversation. Thank you.
Thanks to all the panelists. We have about 10 or 15 minutes, so I can't remember who's got the mic. We'll pass it around. So you all think of a question. I'm going to take my moderator's prerogative and ask a quick one, or maybe not so quick first. One of the common themes that seems to me among all three of your talks was this cooperation, jurisdiction problem with the fact that you've got, religious, public, private, and all three of you, I think, mentioned joint employment or the joint employer doctrine to different degrees. And it's sort of I had maybe a two-part question. One, any thoughts about the legal chances of getting, in particular, the NCAA as the joint employer? Because at least to my mind, that's the key, right? If you can get them, that at least arguably gets over hurdles that you all have talked about. And then if so, what's the likely outcome of that? I mean, is it the NCAA going to start backing off of some of the rules so they can limit the amount of control and maybe avoid that? Josh, you look ready to go, so I'm going to turn it over to you.
Well, I think the obvious outcome of a finding that the NCAA is a joint employer would be that conferences and institutions would disassociate themselves with the NCAA. Whether that is ultimately good or not for the students or for the athletic programs is probably a topic we could fill a whole panel with. But I do think from a legal standpoint, it's an uphill battle for the general counsel or the NLRA. I think even, with Mark saying it, I never thought I'd hear him say it was a dubious proposition, but it's a difficult question, particularly because the goal of joining the NCAA as a joint employer is to assert jurisdiction over the 120 public institutions. And that will create an entire, federalism problem on top of, joint employer and doctrine, whether or not, in the eyes of maybe some of the SEC schools, the federal government should inject itself into something else, would be a very hotly contested issue, and I would suspect make its way to the Supreme Court at some point, who, again, isn't much of a fan of the NCAA anyways, but I think on those types of issues, you might see something that, goes in the NCAA's favor on that.
Yeah, just add a couple of quick things. One is, as a result, in part of Alston saying that the national rules implemented by the NCAA are subject to antitrust attack, but conference-wide rules would not be. The NCAA has delegated more down to the conference level, so it might make it more likely that the conferences are the joint employer, which accomplishes the same purpose because they're also private, and maybe less likely that the NCAA itself is. I would also say there's a parallel track going on in Title IX where there's been an attempt to the NCAA be covered by Title IX, and they have not been. And so you might recall a couple years ago the big issue with the women's basketball players in the tournament and how different their treatment was. And that was not a Title IX violation because Title IX does not apply to the NCAA yet, but there's a thing called the controlling authority doctrine in Title IX. If they exercise enough control over the schools, then Title IX would apply to them as well. So you could see this sort of similar thing where there's a broader interpretation of the law just to accomplish the particular goal. But the last thing I mentioned quickly is, imagine if it turns out that USC is the sole employer of the football players and the basketball players, and then we have the sort of chaos and the patchwork. It's interesting, they would still, just because they're collectively bargaining doesn't mean that they can then violate NCAA rules without having to deal with the repercussions. But what we saw with NIL is that as soon as one state passed a law, every other state, or 35 other states, passed them quickly. It was faster by 5 times, I think, to get NIL laws in 30 states than it was to get seatbelt laws. That took about 12 years. And because of competition. Right? Alabama didn't want to fall behind Florida, didn't want to fall behind California. If there is the opportunity to have athletes collectively bargain and that gives them a recruiting advantage, let's say, would Alabama or Florida, or a state that normally does not try to promote collective bargaining among their public employees, say, wait a minute, we have to choose now between winning our football games or the and being anti-union. And I don't know how they'd come out on that.
Well, isn't it conceivable though? Isn't it conceivable though that conferences could be determined by whether or not they're public or private? And if states decide that they're going to pass legislation excluding public sector athletes in universities from becoming unionized, and conferences are developed, and many NCAAs get developed that are public sector entities, that could take it out of the realm of the NLRA be entitled entirely. Now, whether or not too much money gets lost in that process becomes the question.
Yeah, I had a couple comments on your remarks, if you don't mind. One, I think the likelihood of Alabama encouraging collective bargaining is probably about the same as I would have thought Brett Kavanaugh encouraging collective bargaining was.
Yeah, exactly.
So you never know what we're going to see there.
Yeah.
But I'm glad you brought up Title IX because in your initial remarks you talked about, is college sports special because we treat it special, or is it treated specially because I'm butchering whatever you said, but Title IX is an important part of that, right? We don't have federal legislation that says, for every 50 women you hire, you have to hire 50 men. It is a little bit different of an operating paradigm, and there are all sorts of issues tied into Title IX, even if the students are permitted to collectively bargain. What happens in a scenario where the men's basketball team organize, and as part of those negotiations, agree or gets the university to agree to significant increases in wages or other benefits, facilities, everything like that, but the women's team isn't organized. Does Title IX then function as a one-way ratchet in that the women's team gets the same amount? I mean, because that's what Title IX essentially requires, is substantial proportionality. And, I don't think enough academic thought has been put into sort of what Title IX means in the context of various bargaining groups across the two men's and women's athletics.
I have an answer. So this same issue came up in terms of what happens if we pay college athletes, put aside the union aspect. It becomes part of the budget. If you have $10 million in your budget and you have to spend, which most schools don't, most schools are currently in violation of Title IX, so I think it's sort of ironic that schools are saying, no, but we won't be able to comply with Title IX when they're almost all out of compliance with Title IX. But if you have a $10 million budget, you know that you can spend 5 on the men's team because the other 5 has to go to women. So this would maybe be the best thing to happen for women's athletics, is that the finances, again, assuming Title IX continues to apply if the athletes are employees and they're collectively bargaining, and if not, then we'd have Title VII issues, but that you have to figure out a way to spend in a way that's compliant with Title IX, and then the answer is often, well, then we're going to have to cut sports, and we'll cut men's sports, and we'll have to cut women's sports too, because we just can't afford to do all of that. And say, where are we going to get the money? I said, well, look at your football coach. I don't know, the $12 million you're spending on your football coach, and the $1 million that multiple teams are spending on their assistant coaches, and the $530 million you spent to fire your coaches, and the third waterfall you built in your athletic training facility. I don't know, where would that money come from?
Yeah, so Title IX could be the Davis-Bacon of universities. Yeah.
Sounds like a title for an article. We've got about 5 minutes, so maybe time for 1 or 2 questions. And I think do we need the mic for that, or? Go ahead, go loud.
I've been in general, the Nick Sabans of the world, it's typically a
I
combination.
think because we're recording, you might want to repeat the question, because I don't know.
Oh, yeah. So the question was whether, essentially, what pays for Nick Saban's salary? Does it come from alumni donations? Does it come from the operating budget of the school? It really ends up being sort of one and the same. And it's different depending on how the university and the athletic department is set up. But it is often when a coach is threatening to leave, or if a school wants to hire a new coach, it's typically there's an influx of money from the alumni base to allow them to afford it. Now, whether that goes directly to the coach or they're using a different pool of money that they already have, it's still, many of these schools are spending money from alumni to hire the coaches.
Other question. Probably have time for one more.
But on the salary, there are studies that show that the highest paid employee in a public institution nationwide is the college coach and the athletic director.
Yeah, in about 30 states, I think it is. Yeah. Somehow they make more than the law professors. I don't know what that is. But one other question, one other point, I'm curious to hear the group thoughts on this, is the expression that bad bosses are the best organizers, and that the exploitation of fill-in-the-blank athlete or worker has pushed, particularly more recently, towards unionization. We're seeing kind of the opposite now in college athletics, where college athletes are getting more and more rights. They have more rights now than they've ever had before, with name, image, and likeness, with scholarship, with everything they've been given. Now, you might still say that some of them are underpaid and they would get more in a free market, but for 99 point whatever % of athletes, they are pretty happy with the deal they have. So I wonder if the inverse, if the good boss is the worst organizer, or is there not going to be a push? Because we haven't seen it. And General Counsel issued her memo over a year ago, and not a single athlete publicly has indicated that they want to be a member of the union. As I think you've talked about, the sort of union pushes have been, or the unfair labor practice charges have been by organizations that don't have active athlete representation. And one of them was desperately searching for an athlete, and no one would sign up. And then he found out by, I don't know if he called you, but they said, you don't need an athlete. You can just file the charge. And he said, "Oh, really?"
He didn't find that out from me.
Yeah, yeah.
It might have
The
been
grad
Josh.
student
Might-
unions, which are going crazy right now with all the grad student non-athlete unions, right? So it's not like it's this real disjunct.
Well, Gabe, I think you touched upon it in terms of the kind of pressure that is brought to bear. Well, first of all, you have a paternal relationship that the coach has with the athletes. Then you have so many things factors that go into whether or not you start or whether or not you're going to be recruited, that can disguise retaliation and coercion so easily, and so many arguments can be made. Well, the uniqueness of this athlete was such that athlete could not carry the ball for a Heisman Trophy because of what this other athlete had and what opponents were having. And they are young, and they're told to keep their heads down. If they want, and their lifespan, their shelf life in the sport is a short one, and regrettably that has its impact. It's probably not too dissimilar to other professions where at the college level their shelf life is shorter. Yet there has been organizing. I mean, I parallel the athletes a lot to interns and residents, and they've been able to effectively organize.
We're getting the not so subtle. It's time. So join me in thanking this great panel.